Good afternoon. The more astute of you may have noticed that I am in fact not Australia's first Aboriginal silk, Tony McAvoy, SC. For those of you lucky enough never to have met me, my name's Chris Ronalds, and among other things I'm the trustee of with Michael Slattery, Justice Slattery here, of the Indigenous Barristers Trust, and we're one of the co-hosts for this triple-hosted seminar this afternoon. You are all welcome to the Bar Association. I acknowledge that we are meeting on Aboriginal land, always was and always will be. We have a wonderful program, and I'll just briefly outline what we're going to do. June Oscar will speak for about 30 minutes. Her Honour will speak for about 10 minutes, and then we'll open up to questions and discussions in a general session, and then we would invite you all to join us for a drink afterwards to have an informal discussion about the issues that have been raised. As you would have seen on the flyer, June Oscar AO was awarded the International 2016 Desmond Tutu Fellow, which is a recognition of her role and recognition of her role internationally in the important work that she's done. She has championed and led the community health and social reforms in Fitzroy Crossing in the wilds of Western Australia to tackle and eradicate the social, psychological and community dysfunction arising from Aboriginal early childhood trauma and Foetal Alcohol Spectrum Disorder, commonly referred to as FASD. Tonight, we are honoured to be able to hear from her about the actions she has led to support a significant change in her community and to demonstrate to the rest of Australia that change driven by and from the community itself is the only proper way for meaningful change to be achieved. Despite her humble presentation, June is in fact one of Australia's most outstanding Aboriginal women leaders. Please welcome our distinguished guest.
Chalongurulaingo, Palangare. Ngani Nyanjili, Ngajitanga Winyingra, Ngajangara Punova. Good evening, ladies and gentlemen. This language you hear is my language, Punova. Thank you for attending tonight and making time to be here. It's great to be here with you. I too would like to acknowledge the traditional owners of the land we meet on today, and I pay my deep respects to the elders of families, both past and present, and the generations to come. I also want to acknowledge and thank the organisers of this event, and a big thank you to Chris Ronalds for organising and ensuring that I get here to share this evening with you and to present a snippet of our journey. So thank you all. I'd like to also acknowledge my own community in the Kimberley, Fitzroy Crossing, the Fitzroy Valley, the home of Bunaba, Guniandi, Walmajari and Wangajunga people and Nyigina people. I would further like to acknowledge the Marulu team members and our partners, the Telethon Institute for Child Health, the George Institute for Global Health, and the Discipline for Paediatrics and Child Health at the University of Sydney. I will come to an explanation of their wonderful work with us later, but I would also like to give particular thanks to Lindsay Kane and her team at Royal Far West, a team that are very valued partners to all of us in the Fitzroy Valley, partners and close friends. I'm sure when any of you hear the phrase, often said with great conviction, that I will be taking the law into my own hands, you groan, take a deep breath, and wait for the inevitable damning consequences. Well, tonight, as I tell you the story of how many women in the Fitzroy Valley came together and took the law into our own hands, you'll let out a sigh of relief. From here, in the remote north of Western Australia, in the Fitzroy Valley, where I grew up and continue to work and live, I was involved in a small and immensely important revolution. We revolted to unite with legislators to overcome our historical boundaries and amend the law so it would uphold our rights. I want to begin with a necessary clause for my defence in case I'm held up against my pronouncement on the law tonight. You know, I'm no lawyer, and I can't claim to be a bush lawyer either, but I'm fully aware of the power of the law in upholding the rights of my people and protecting us from all forms of discrimination and harms, while enabling our freedoms and enhancing processes of self-determination. I know this because of the journey we are on as Indigenous peoples to be effectively incorporated and fully recognised in the legal and governance framework of this nation state. The journey to incorporate our rights into domestic law is one we've been on since colonisation. It is this journey for recognition and acknowledgement within the judicial framework means we as Aboriginal people have an intimate relationship with the law like few other populations in Australia. We understand the profound power of the law to effect change. The legal apparatus of this nation has had such a severe intervention on our traditional societal formations that we've grown accustomed to opposing it, to seeing the law as our enemy. That is no surprise when we witness the horrors of Don Dale, institutionalised systemic abuse, or when we reflect on 25 years of the Deaths in Custody Royal Commission and see how our interactions with the criminal justice system have only increased to devastating proportions. We all know the statistics. Since Don Dale and the announcement of a Royal Commission, the numbers have been said time and again. Aboriginal people, as only 3% of the Australian population, are the most overrepresented peoples in the criminal justice system. Since 2004, Aboriginal Australians in custody have increased by 88%. Once convicted for your first offence, for many, the lifelong cycle of re-incarceration is somewhat inevitable. On all accounts, this current state is unacceptable. The figure's real, but unimaginable. However, this talk tonight is not about lamenting the unacceptable. It is about bringing together the evidence of what we know can work and acting on it together. It is about acting with a renewed vigour to unite communities, the social service sector, research institutions, and the criminal justice system as one. A united approach that ensures evidence, program planning, and processes of justice are informed by those on the ground. This system would act cohesively, founded on the principles that every human being has a voice that needs to be heard, has rights and freedoms that must be upheld and protected, and is capable of determining a healthy and strong future when information and opportunities are available to them. The question is, how do we do this? How do we act as a cohesive system, responding to the rights of individuals and the needs and strengths of families and communities? My focus today is on our legal framework. So this is where I'll begin. Firstly, can we see the law as a friend, as a means to our safety, care, and ultimately lifelong success? I know we can. In the Fitzroy Valley, taking the law into our own hands did not mean becoming the adjudicators. It meant feeling the law, to grasp its meaning, to personalize it, and make the system of justice accountable to us. We know societal transformation is not possible if there are not real alternatives to incarceration. This means we need community-based programs of rehabilitation alongside good education and meaningful employment. In retilting the scales of justice in our favour, we have to have a shared understanding of the societal harms we are experiencing, where they have come from, and are working to overcome. The Fitzroy Valley is essentially an Aboriginal domain. 3,000 people from 5 language groups live in today's 30-odd communities. Fitzroy Crossing is the only town and is the service hub for these communities. Like Indigenous people throughout Australia, we live with the inherited trauma from invasion and prolonged frontier conflict. In our case, not that long ago, in my grandparents' lifetime. We lived as unpaid cattle station workers for 2 to 3 generations until thousands of Aboriginal people across northern and remote Australia were summarily evicted by the station masters when Australian law intervened to end the exploitative feudal era and imposed equal wages. Our people were thrown onto reserves on the edges or concentrated makeshift camps. Fitzroy Crossing's population grew from approximately 100 people to more than 2,000 in a few short years. Living conditions were deplorable, and amidst the peak of the Kimberley's population displacement turmoil, the state government amended the Liquor Act to remove all restrictions on Kimberley Aboriginal people's access to alcohol. It was done in the name of reforming discrimination laws, but it happened without any engagement or planning with the people who would be affected most. Since the 1970s, the horrific consequences of alcohol on our community has worsened year after year after year. Although we achieved great success and we have remained resilient, building from the strengths of our remarkable heritage, we still live within the context of trauma. In the year 2005-06, the Fitzroy Valley community had attended 50 funerals. This included 13 suicides. Many deaths were in young people, and most were alcohol related. The state coroner, Alistair Hope, concluded that alcohol abuse is both a cause and a result of many problems for Aboriginal people in the Kimberley. The problems associated with alcohol abuse are the most obvious and the most pervasive. By 2007, the grog crisis could no longer be ignored. That's when we, as the women of the Fitzroy Valley, stepped in. We could no longer act in crisis. We had to act with care, consideration, and foresight for the health and well-being of future generations. Instead of blaming legal authorities, we calmly reflected on the purpose of the law. We did something rarely done. We overcame historical distrust and animosity and worked with the police with a shared genuine concern for our people's welfare. We rallied to action. With the support of the Police Commissioner of Western Australia, our community intervention used the Liquor Licensing Act to respond to our community's needs. The police stood beside us every step of the way. The result was, instead of the law privileging the vested interests of the liquor industry, it now privileges our human rights, and in the process has improved relationships with the very institutions designed to protect our society and uphold the law. The restrictions have now been in place for 9 years. It has made the Valley a calmer, more peaceful place in which to plan for a society which presents real alternatives to imprisonment. In the Fitzroy Valley, we are already putting the building blocks in place for a community restoration that meets our regional needs. There is no other place to look when prioritising human rights than our youth. We knew from witness and statistical accounts that drinking had taken a huge toll on our children. We have one of the highest youth suicide rates in the world and one of the highest youth conviction rates in this country. Our greatest concern was how alcohol had become a contributing factor in producing these life-ending and damaging statistics. In 2009, after a long period of community consultation, we embarked on Australia's first prevalent study of Foetal Alcohol Spectrum Disorders, or FASD. FASD are a group of conditions characterized by brain injury that is caused by prenatal exposure to alcohol. Some of these kids with brain injury look quite normal, but they struggle in their development. FASD is lifelong, but it is 100% preventable. We found that 1 in 5 children, 19%, had one of the fetal alcohol spectrum disorders, one of the highest prevalence rates in the world. What this study shows is that many children in Fitzroy have problems with memory, with learning, and academic achievement. Some have problems with writing and fine motor tasks, attention deficits, and emotional outbursts when confronted with authority. Children as young as 7 have mental health issues, including self-harm, talk of suicide, and use of drugs and alcohol. These children are vulnerable to many things, to sexual abuse and family and domestic violence, and many have contact with child protection services regularly. Overall, the key problem for teachers and caregivers is the difficult behaviours that will predispose these children to school failure, contact with juvenile justice, and risks of incarceration. 5 years on, we see children from our cohort involved in petty crime, drug use, and inappropriate sexual behaviour. Is this where our engagement with the criminal justice system begins? Trauma is clearly leaving its imprint, not just in our emotional responses and reactions to life when we are in pain and grief, but in our very neurological and physiological makeup. It is transmitted and it transforms societies from one generation to the next. And unfortunately, the consequences, without adequate support structures in place, see many of our people behind bars unnecessarily. This is our present reality. Now, with the evidence, we can act. This is where we encounter the problem. The problem is not with recognizing and knowing how to respond to intergenerational trauma, early life trauma and FASD, and all associated harms. The problem is that our systems are wholly inadequate in dealing with what needs to be done. We are funded to operate in sectors and silos. It is this that we are working to rectify. Our strategic approach is cross-disciplinary and collaborative. An example of this is the development of our Marulu strategy. Marulu is a Bunaba word meaning precious and worth nurturing. A strategy, a multidisciplinary service provision strategy, uniting community, research institutions, and other organisations to provide innovative, ongoing responses to the reality of FASD. We have initiated a range of interventions, school-based activities, parent support programs, and educational resources for teachers, learning how to respond and work with children with FASD. We are wanting to develop a similar resource for police and the criminal justice system as a whole. We are doing this by working with people from a range of backgrounds, because we cannot provide relevant resources or intervene in a positive way if we do not bring people together from varied sectors. As we build on this approach, we are also shifting who has the power in this system. Rather than decisions lying with the bureaucrats and the service providers, we are giving choice to people on the ground. At the centre of our system of support is the child and our families. We are not here to impose on them, but respond to their strengths and build capacities. In creating this new model, we are commencing an exciting partnership with Royal Far West, based here in Manly, where we are learning how clinicians work together in an integrated approach to care for a child based on a full understanding of that child's circumstances and how to support the family. We are also learning much from their trauma-informed approach to work as we embark on our journey of becoming a trauma-informed organisation and community of shared practice. Lindsay Kane, the CEO of Royal Far West, here tonight. It is people such as Lindsay and my close friend and initiator of the FASD prevalence study, Professor Elizabeth Elliott, also based in Sydney, amongst other great minds and spirits, who are branching out and changing the way we operate, changing the system, It takes courage to move beyond your operational remit, to say, like Lindsay, let's work together across disciplines, across sectors, across distance. To say we have the clinicians, we have the trauma-informed evidence, let's apply it to your setting and work together to implement the right community-led process. This is challenging and very exciting work. Apart from the wonderful determination and conviction of our partners, and that includes many people in government, the system we operate in means our work is vulnerable when it needs to be secure and stable. As a follow-up to the Don Dale Four Corners episode, there was a Four Corners program on Burke and its whole of community justice reinvestment strategy. It was based on many of the principles of engagement across sectors that I've spoken of tonight. It looks at redirecting funds from incarceration to community programs and local methods of rehabilitation. Burke, similar to Fitzroy Valley, is taking steps to change the system. These examples of how communities can function and work within the law to achieve freedoms, not to have them denied through incarceration, are our solutions for a better future. We have the evidence in the Fitzroy Valley to inform us of the best ways to target investment for the greatest impact. For instance, we could work with the police force and magistrates to recognise and respond appropriately to those with FASD and other complex needs. The block in our development journey comes when we are not resourced to deliver this training. The block is there when we can clearly imagine the alternative program that a magistrate can refer a child to other than detention, but we are not funding that program to exist. The block comes when the child with complex needs requires particular clinical support, but that support is based thousands of kilometres away. Justice reinvestment provides a funding model that can properly resource the essential infrastructure for communities on the ground to grow initiatives such as ours. The future we want to invest in has a firm commitment to upholding the rights of our children alive today and those who will be born. Unfortunately, our investments are vulnerable to the whims of political policies. The system we operate in means our work is vulnerable when it needs to be absolutely secure and stable. Our work has to move beyond politics. Although the Australian government are signatories to many United Nations conventions, few, such as the Convention on the Rights of the Child or the rights of Indigenous peoples, have been incorporated into domestic legislation. When it comes to funding our basic rights, governments are not legally obliged to respond. To act, then we must have people willing to work alongside us, who understand the sanctity of the law and the need to protect our rights. Some of the most important people are you. All those involved in the legal apparatus of this nation, who collectively hold the knowledge of justice. When we work together, we can redefine the system. We can understand how the law can uphold our rights, and we can share justice across the community. So justice does not have to be decided on at the point of crisis in a court when the damage is already done. Today, for many Aboriginal families and communities, the law is ultimately a drive to regain the freedoms that have been lost. As we work toward recapturing our freedoms, we are establishing a robust legal framework to protect us and care for us. A framework grounded in a belief that incarceration is always and necessarily a last resort. We know what is needed. We need to work on initiatives that will respond to the evidence, so we can heal the wounds, so we can end transmitted trauma, so we know that in generations to come, our society will be restored to full health, well-being and vibrancy. Committing to this journey is how justice will be served. So thank you.
Thank you, June. Sure. With a hard act to follow for poor Dina, but never mind. Judge Yahir SC was admitted as a solicitor in 1989 and worked with the Western Aboriginal Legal Service from December 1989 until September 1996. In that role, she represented thousands of Aboriginal people, which is a comment on itself, really, in towns such as Burke, Bree, Wilconia and Broken Hill. She was called to the bar in 1999 and took silk in 2009 and became the first female Deputy Senior Public Defender in 2013. Dina and I have a very odd link, which is that on the same day we both got special leave in the High Court. She got special leave for Bug Me. I got special leave for the Palm Island Alcohol Management Plan, and we both spectacularly lost. So there you are. Her Honour was appointed as a District Court Judge in May 2014. She's the chairperson of the District Koori Court Working Group, and that's which she's going to speak to us about today. Thank you, Dina.
Thanks, Chris. Firstly, I want to acknowledge the traditional owners of the land on which we meet and pay my respects to their elders past and present. Secondly, I want to thank Chris for organising and chairing this session, and I also want to take the opportunity to acknowledge and thank her for the support, guidance and mentoring that she has given to Aboriginal and Torres Strait Islander students and practitioners. She's been doing that now for many, many years, and I think that it's important to publicly acknowledge that. I want to thank June for that very insightful and thought-provoking talk, and I hope we can get time to discuss some of the issues raised by June more fully. Chris asked me to give a brief overview, I think I've got 10 minutes, of the proposal to establish a Koori Court as a division of the New South Wales District Court. Firstly, let me tell you something about how the proposal came about. I think this audience would know the appalling overrepresentation of Aboriginal and Torres Strait Islanders in our prisons. You know the statistics, but I'm going to repeat them because I think we need to repeat them every chance we get just to understand how appalling the situation is. Aboriginal and Torres Strait Islander men comprise over 23% of the male prison population, women over 30% of the female prison population, and children over 50% of juveniles detained. In many Aboriginal communities, families have one, if not more, family members in prison, or one or more family members who have had direct contact with the criminal justice system. Across this country, the overrepresentation of Aboriginal and Torres Strait Islanders in the prison system can only be described as a crisis. One of the reasons, therefore, for the proposal is an attempt to find ways to reduce the number of Aboriginal and Torres Strait Islander people being locked up. A related reason is that often the first time that the underlying issues that give rise to the offending conduct are addressed in any way at all is after a person has been charged and is appearing for sentence. Ideally, of course, underlying issues such as mental illness, substance abuse, intergenerational trauma, unemployment, illiteracy are all matters that should be dealt with much earlier than at the point of entry into the criminal justice system. Indeed, if those issues were addressed at an earlier point, we'd have much fewer people entering the criminal justice system. There are, of course, many grassroots initiatives and community initiatives that strive to address these underlying issues. And you've heard about some of those wonderful initiatives from June. But the reality is that there are still too many cases where the individual or the underlying issues relating to an individual are identified and addressed for the first time when they come before us for sentence. Now, of course, the criminal justice system can't do very much about things like poverty, can't do very much about things like cultural dispossession. But there are a number of things that we can do a whole lot better. The Victorian County Court established a Koori Court in 2008. By all accounts, the results have been positive in terms of greater or an increase in positive engagement between the participants and community with the court, and also a reduction in recidivism rates. We know from the evaluation of our own New South Wales Drug Court that that has been quite successful. Again, there's been greater engagement between participants and the court, which is evidenced by an increase in compliance with court orders and also a reduction in recidivism rates. There are a number of Aboriginal sentencing courts across Australia. In New South Wales, in the main, they are in the local court or at the local court jurisdiction. The Youth Koori Court pilot has been in place for 18 months. Magistrate Sue Duncombe, who I see is here, presides over that court, and that court is doing remarkable work. So it was time, therefore, to consider a proposal for the establishment of a Koori Court in the District Court jurisdiction. The Chief Judge of the New South Wales District Court was and is extremely supportive of the initiative and was very supportive of forming a working group to put together the proposal. The objectives of the proposed New South Wales District Koori Court are to enhance the level of court support provided to Aboriginal and Torres Strait Islander offenders and victims, to increase the level of compliance by Aboriginal and Torres Strait Islanders with community-based orders, to reduce the frequency and seriousness of offending, where appropriate to reduce the amount of time spent by Indigenous offenders in custody, to increase the awareness of Aboriginal and Torres Strait Islander offenders of the consequences of their offences on victims and communities to which they belong, to enhance the confidence of communities in the courts and in the administration of justice. It's proposed that some of the mechanisms or procedures that we should adopt to achieve these objectives, if the court is established, are as follows. Firstly, the involvement of elders or respected community members in the court and the presence of Aboriginal and Torres Strait Islander staff, including, for instance, Koori Court officers who, amongst other things, will liaise between the court, offenders, service providers and elders. Secondly, the use of specialist reports as a way of placing evidence before the court that is relevant to the individual participant, but also informs the court about the history of that person's community, including matters relevant to the impact of intergenerational trauma. We hope to be able to see the presentation of Gladue-style reports to assist the court in assessing the participant's history of disadvantage and deprivation, and also in assisting the court to structure an appropriate sentence. The difficulty will be securing funding for reports such as these, but I am advised that the Aboriginal Legal Service has been conducting a project looking at the preparation of community reports, and we hope that if the court is established, it will be able to encourage and facilitate the preparation and use of such reports. Another project that is being worked on is a collaboration between the University of New South Wales, the Faculty of Law there, and the Aboriginal Legal Service to support mental health professionals and social workers in presenting to the court important cultural issues within mental health and social work evaluations. This would include the factors relevant to and the impact of intergenerational trauma, and also matters related to Foetal Alcohol Spectrum Disorder. That project aims to improve the quality of mental health information before the court for Aboriginal and Torres Strait Islander offenders, and to increase referrals both by legal services and the courts to culturally appropriate healthcare for offenders. The project will provide the development of skills to Aboriginal and Torres Strait Islander mental health professionals through improving their understanding of the legal system and the procedures adopted, giving evidence, writing reports, things of that kind. And the project is also focused on increasing the number of Aboriginal and Torres Strait Islander mental health professionals taking part in the court process. The advisory or the steering committee includes Sue Green, Jill Hunter and Rebecca McMahon, who should be congratulated for their efforts. My own experience when I worked in Western New South Wales, as you heard, I worked in communities such as Burkbury, Warren and Wilcannia, is that families experienced a level of emotional and psychological trauma that is sometimes crippling. Many families experienced multiple trauma caused by the death of family members from early onset ill health, suicides, trauma caused by children being removed, mass incarceration, substance abuse and violence. There was no trauma or grief counselling. People were just expected to get on with it. Often these difficulties are compounded by poverty, unemployment and inadequate educational facilities. So by having reports that specifically address the particular circumstances of the individual, informed by the historical, cultural, social and economic circumstances of the community from which the offender comes, the court will have a better understanding of the relevant factors to be taken into account when sentencing that individual, and will be better able to structure an appropriate sentence. Now, I don't have time to go into the details of the model itself, but perhaps what I can do is just share with you some of the salient features. I think some of the important features is the involvement of community through the elders or other respected persons, the presence of Aboriginal and Torres Strait Islander staff in the court process, detailed and culturally specific reports, intensive involvement by community corrections and other service providers. And in the course of preparing the proposal, there have been a number of consultations with grassroots organisations such as Tribal Warrior, New Horizons, the Warringah Baya Aboriginal Women's Legal Centre, the Marin-Wajali Aboriginal Corporation, the New South Wales Aboriginal Land Council, and many other organisations. So there are organisations out there, we just have to consult and get them involved. The other features of the model is increased sentencing options that we've called for in the proposal, and a greater monitoring role for the court once sentence is imposed. At the moment, under the current provisions, the power that we have to monitor the progress of a particular offender is by way of Section 11 remands. But once somebody is sentenced, we have no role in monitoring their progress. I think in Victoria it's quite different, but in New South Wales that's the position. So one of the options that we've asked for is a process whereby the court, once the offender is sentenced, has a monitoring role in 3 phases: high supervision, medium supervision, low supervision. So initially, for a period of 3 months or so, the offender will be required to report back to the court twice a week, either in person or by way of AVL, if in a residential rehabilitation unit, for instance. They will be drug and alcohol tested on a weekly basis. So there's quite high supervision. And then there's medium and then there's low. My own experience in the short time that I've been on the bench is that offenders generally respond more positively when the court has a greater role in monitoring their progress. As I've said, we have a limited role in that respect at the moment. So hopefully, if the court is established, that will be one of the things that will change. I think my time is up. I'll just say in closing that we hope that the proposal is approved and the pilot commences. I think we have to find a way of engaging with Aboriginal and Torres Strait Islander communities in making the process of the administration of justice more relevant and more effective, and to promote mutual respect. Thank you.
Thanks, Dina. Now, for those of you who are familiar with this process, each of the three organisations obtain a copy of the recording, but it doesn't record in the room, it only records up here. This requires me to repeat the question when it's asked by someone. If someone wants to make a longer statement, I invite them to come up and speak into the mic, and so that will be easier. So, questions? Oh, come on, guys.
I'd like to just ask Dina, because I'm interested anyway, from my own our court perspective, how likely is it that this is going to happen, and if so, when?
An unnamed judge inquired whether how likely it was to happen, and if so, when. Dina, you have to come up to the microphone. Unfortunately, you're not in cabinet, you don't know.
I want to answer this diplomatically because it's being recorded. No, it's being recorded.
It's being recorded.
Look, I think we are hopeful that it will happen. It's obviously an initiative that will take some consideration because it will require legislation. So we're hoping that we see some progress next year.
Diplomacy award for the night goes to Dina. Justice Slattery.
We all know how hard law reform can be. One of the things which I find most fascinating about what June said is that you've been able to use existing law to introduce the alcohol restrictions. And I was very interested to know how you did that. Did you use the court system? Did you have to lobby bureaucrats? What was the opposition from the liquor industry? What allies did you get to achieve that first change?
The short version is, what was the process that engaged in to change the liquor laws, and what opposition was there?
Thank you. Thank you for the question. It was interesting. We applied, to the regulating authority and sought to inform the government, the cabinet about it. And I had the Premier say to me that I'm just competing for the leadership in Fitzroy Crossing with the men. I was very disappointed 9 years ago when that was said to me. And I proceeded to seek a meeting with the State Police Commissioner and to say, this needs to happen, this needs your support and cooperation. We cannot do this on our own. So he immediately held a press conference at police headquarters and announced that he would be supporting the women of the Fitzroy Valley. As soon as that public statement was made by him, the Premier of Western Australia moved in behind him and supported it. The opposition was very well resourced and moved immediately to create confusion in the community and describe us as highly emotive women, and proceeded to have people from in the industry challenge us around the figures of people affected by fetal alcohol spectrum disorders, and that it was only 1 in every 1,000 births. And so that just helped us to really become so determined to present the evidence, to conduct a prevalence study, to present the community with the opportunity of understanding exactly the impact of chronic oversupply of alcohol and the damage to the populations of children. So now we have the evidence, and we hope that that will speak for itself, but we're continuing to make that available to everyone.
It's a question about the funding or possible funding of the district Koori Court. I think that goes in the same diplomatic bag as the last question.
Look, in terms of the pilot, the funding that has been sought for the ALS, legal aid, and DPP, because it will require ideally a specialist unit, so they'll have to have extra staff. The court itself has not sought extra funding for the pilot. And I think that has largely been because it was the view of the Chief Judge and myself that we really want to get this started. And we could absorb the costs, at least for the pilot, within the existing court funding.
Sorry, you're behind the pole. So it's essentially a question about the additional infrastructure supports that will be put in place. If I could just comment on the Victorian Koori Court, if I may. I was down there recently, and they have now released a new study, which some of you might have seen, that Aboriginal prisoners are refusing parole and serving out their full sentence so that they're not subject to continuing supervision because they don't have a accommodation that will meet the requirements, and so they actually choose to not even apply, and they stay in jail for their full sentence because when it's finished then they won't be supervised, but otherwise they have no access to alcohol or drug-free accommodation, and so they won't get it anyway. So that's a pretty tragic outcome as well.
Sophie, I think in terms of juveniles, Sue would probably be better placed to perhaps answer the question with respect to the programs that have been put in place as a result of the Children's Koori Court pilot. That's something that I think Sue should speak about. Obviously, one of the difficulties is going to be in funding programs, rehabilitation programs, so that people will have somewhere to go, because the whole purpose of this initiative is to find alternatives to full-time custody where appropriate. The organisations that we've consulted with, and some of the ones I've read out and there are others, have all been very supportive of the initiative, want to be involved and will be engaged around the table. It will, once it's up and running, those organisations will probably have to seek further funding for increased placements in order to deal with the number of matters that will be referred to them. So again, this is all a process that is taking place. It's been slow, but it is taking place, and I think the first step is to see whether approval is forthcoming to set it up and to start engaging those service providers. And as I say, once that gets going, they will be applying for further funding to increase the placements, because at present, as you've highlighted, there is a real difficulty even in the mainstream referring somebody off, for instance, to full-time drug and alcohol rehabilitation because the beds are so scarce at the moment. And in a number of cases I've had recently, there's a 3-month wait for somebody to even get a bed. So it is an issue. It's a funding issue, I think, but if there is going to be approval for this proposal, then I think that those organisations will be lobbying quite hard for extra funding so that they can have the placements available. And I should say the Curricord officers will have a very significant role in terms of liaising, as I said earlier, between the offenders, service providers, the programs, etc., which will include things like taking people potentially to programs.
I should have said before to save you writing notes, but sorry. For those of you who followed the rules and registered and provided an email address, we will be sending out a copy of June's paper and also a 2-page sheet of information prepared by the staff of the Judicial Commission, which will have hyperlinks to the leading FASD cases in the US and Canada, for those of you who are interested in following it up, and also a list of New South Wales resources and relevant research projects for those of you who would like to follow it up a bit further, and we'll send that out next week. Justice Slattery has another question.
If I can be allowed a second question, I'm also very interested in whether or not you can measure any success in your program by decline in fetal alcohol syndrome births in the last 3 to 5 years, and what do the figures look like if that is so?
The question about the decline, if any, the answer is yes, to fetal alcohol syndrome in the Fitzroy since the rivers of grog have stopped running.
Yes, thankfully, we have been able to engage the public health sector and the midwives in community health to monitor women who are coming in and seeking out antenatal support, who are abstaining from alcohol immediately. So there's been a huge reduction in women consuming alcohol who are also having babies. We're finding that the older women who are pregnant are having real difficulty with abstaining, and I think that speaks to given age to addictions and longer term use of alcohol. But there has been a very noticeable reduction in women drinking, and that for the first time in 25 years, our healthy live birth weights have exceeded median levels of the World Health Organization. So we are having healthy babies being born in the Fitzroy Valley since 2007.
I might just add to that. As some of you know, I've had a lot to do with Palm Island recently, which has a government-imposed alcohol management plan, not the community. Didn't rise up, it came down. It's not supported by the community. you should only be able to get, this is not true, but you should only be able to get light beer on Palm Island at any stage. However, there is an alarming rate of FASD, so you would have to think that perhaps it's not working. And if it doesn't have community support and it isn't supported by the community and doesn't come up from the community, it won't be embraced. Palm Island's awash with illegal grog, literally, and now ice. So it's a real stark contrast of those two communities have quite a lot of common factors, Fitzroy and Palm, and it's a tragedy to see what's happening on Palm, which still has terrible youth suicide rate, particularly young blokes when they come out of incarceration. Susan. I'll get off my hobby horse now.
A question for June. What are the current biggest hurdles to be overcome, given I know there were a lot in the beginning, but what are the primary obstacles and challenges that are being met now?
What are the primary obstacles and barriers now being met?
In Fitzroy, in the implementation of your program?
Firstly, with having huge issues around convincing government to support Australia's first ever community-driven FASD unit, from, coming out of Australia's first ever prevalence study driven by a community. So funding the support for the ongoing next stages of support to families is a real difficulty. So that's real. To ensure that children are accessing therapeutic supports in education is still a huge hurdle. To convince those that direct the finance in the state and in the Commonwealth to support these models, innovative community identified driven models, is still an issue. So the community also has been able to understand the impact of alcohol since the restrictions, and it's no longer a huge debate in the community that the alcohol has had a negative impact, because people are able to see and understand and are part of designing the supports that they need. And I wanted to I should have mentioned this earlier, around the research that we had, or the survey that we had conducted across the valley in gauging the numbers in our population who now are aware of FASD. And we have over 60% of our population very aware of FASD and the causes and the needs of children and families affected by it. So since 2007 and prior to 2007, FASD was unheard of. People did not understand what it was. Now we have a significant number of our community members who are now aware. They're self-policing, so they take it upon themselves to intervene when there's alcohol around and there's women who are of childbearing age around. So people are becoming accountable for themselves and in their own spaces, and not just leaving it to organisations and service providers. So, yeah. So funding is a huge issue, the ongoing commitment to that.
Steve?
Thank you, June and Christina, for your presentation. Very powerful presentation, June, and an excellent presentation, Peter. I didn't want to ask a question, but I want to mention someone who I think June would know, Chief Justice from Western Australia. He's been a very powerful advocate in a range of ways in relation to FASD and other matters affecting Aboriginal people. It's a matter of information that about a week ago, 10 days ago, he published a very powerful judgment. It's LCM, I think, in the state of Western Australia, in the Court of Appeal, and about 5 or 6 pages, apart from surveying some of the Canadian and other authorities which are going to be hyperlinked. He discussed in great detail, but succinctly, the challenges of the criminal justice system with FASD in Western Australia and the absolute failure of the government and the authorities to diagnose it and to provide support to the people that suffer from that condition. And I recommend that judgment because the judgment is a lengthy judgment. The other 2 judges deal with the nuts and bolts of the appeal. Mine's 5 or 6 pages are really worth reading.
Thanks, Steve. Well, thank you. I'm sure the Judicial Commission can sort out the reference to a West Australian case in the Court of Appeal. Thanks. There was one person up the back there. You'll have to project your... It's an issue about cultural competency and I assume training for those who may need it, including perhaps the police. Did I say that? Do you want to say anything about
Well, for what I need to understand it better. What for all of our government and non-government partners and stakeholders that we're engaging with, we have within our organisation at least a cultural competency program and an approach, and we're good judges of what that should look like and how people should engage, and so we set the bar quite high for that, and we know that the responsibility is on us to ensure that the understanding and the competencies and the outcomes that we're looking for is something that we're going to accept. So we do that on a daily basis as an Indigenous service. And where did that question come from? Yeah. So yeah. I can't hear you. There's too much noise there. It's difficult for me to hear you. Oh, maybe for you. I think for you. And the other thing with Fitzroy Crossing, because we focused in on the service providers across the spectrum in Fitzroy. Now, Fitzroy Crossing is a very strong cultural community. We have 5 different languages other than English spoken there. So cultural competencies, communications, understandings is absolutely what we engage in every day with all of those individuals and organisations. So there's an expectation from us, but we're also helping to create the understanding, to help facilitate that understanding, so that we have people in there, regardless of whether they're engaging with people with an FASD, but when they're engaging with our community, they're absolutely aware of what's required of them. But we, as the Indigenous people, are ensuring that we're delivering on that and not waiting until there's a problem and a breakdown in one's ability to have the cultural intelligence to understand issues better. So we're on the front foot of all of that.
I think, if I understand your question correctly, I'll answer it in two parts. In terms of cultural competency, the proposal that we put in place will involve training for judges who are interested in sitting on the court. So in terms of that type of cultural competency, yes, there'll be training, and I imagine that will be put together by the Judicial Commission. But I think, if I understand your question properly, you're talking about the general public's response to these initiatives. Is that right? And any potential opposition to such initiatives? Have I understood that correctly? Well, in terms of the proposal for the Koori Court, I mean, one of the things that I think there's going to be a significant emphasis upon is engaging as many Aboriginal and Torres Strait Islanders to work in the court. So I don't think they're going to require any cultural competency. So that's one of the significant initiatives of the court, is to have Koori Court officers, is to have community corrections officers who are Aboriginal and Torres Strait Islanders, to have service providers that include grassroots Aboriginal organisations coming along and being engaged in terms of the rehabilitation program. So that's the initiative. Ideally, that's what we want to see in the court, more Aboriginal and Torres Strait Islander people. In terms of the lawyers, there will be training. So the DPP, legal aid, again, Aboriginal Legal Service query whether you need training. They've been doing it forever. I think they know the issues. And for judges, as I've said, there would be training. In terms of the public reaction to the initiative, well, I think that's a long-term process of education. And there was criticism levelled among some segments of the non-Indigenous community in Victoria when the Koori Court was set up there. But I think we can deal with that.
Perhaps one last question, Lindsay.
It's not a question, if I might just respond to that. Having the honour of working with June Fitzroy from Command, and I'm from Royal Poet. What June's not telling you is the amount of...
Go to them. Come round this side.
Thank you. I'll come round there. Thank you. What June hasn't said is the amount of opposition that she originally met from the community, many of June's family, relatives, and Emily Carter, her business partner. The two of them met some great resistance in the beginning. But what I've seen and what others have seen is cultural competence translating to simple on the ground. What does that mean? Absolute conviction. June has said to me at the beginning, we will lead our people to a harm-free valley. We will not have FASD. She's stuck to that and she holds that. So what's happening in Fitzroy is that's up louder than anything. So all of the agencies that are working in Fitzroy are working with June and Emily with that conviction first. They've had to buy into that. You've had some very unpopular experiences with direct family members who didn't want the grog controlled, but they've held their line and they've brought people with them. The power of June, this woman, is she's incredible at getting people to follow. And that's really important. The leadership has to have great followers, but the town's coming to this single soul conviction that they want a FASD-free valley. So that's what I would call cultural competence. And the best example for me was when I was in Fitzroy and I heard the story about the police. 18% of the kids attend school, 18% of the kids. Many of them are wandering the street, dysfunctional. Some of them can't dress themselves because they can't do fine gross motor coordination. They don't have higher functions. Their parents are maybe not to be found, but the kids are not attending school like they should. Now, we know how the police sometimes operate in some towns. The police know this is happening. They bought into the FASD Free Valley. They're working with June because they're also part of I forget what it's called, is it Fitzroy Futures? June initiates something called the Fitzroy Futures. So all the key stakeholders in the town belong to this planning group that are planning the future of the valley. So everyone's involved. Everyone's integrated into the solution. The police, there's one story I would like to share with you. A little 10-year-old boy who is not a great attender at school, has a lot of dysfunction and loves to go off into the bush on his own at any time of the day or night. Obviously that causes great stress to the parents and the family of this little boy. What the police do, because he loves flashing lights, what the police do when they know that this little boy has gone missing again is they get the cars out, they go into the bush, they turn on the lights and they find him and he comes home. So for me that's a demonstration of people working together around a very important function. And June's really the architect of that with her great friend Emily Carter, and I think this is a great story about women, Aboriginal women, understanding how do you get communities to work together. So thank you for allowing me to tell you that.
Thank you, Nick. I'd like to invite you now to turn the other way and wander down the back and join us for a drink. And have a drink. And I can tell you all these snacks are gluten-free for those it matters to. So we would like to thank our two speakers in the usual way, and please stay and have an informal discussion.